Hello guys, welcome to another episode of this particular video. By name, I am Jafet Okaka Ebosetali, and today we are going to be looking at commercial law. So today we are going to be looking at commercial law, and under commercial law we are going to be dwelling on terms of a contract of sale. Now this particular topic falls under the sales of goods, but specifically under the sales of goods we are going to be looking at terms of a contract of sale, and we are going to also be discussing condition, warranty, and we're going to be answering the question whether or not time is actually of essence in a contract of sale. However, before diving into this major aspect, it is pertinent to first of all lay a proper foundation, and which is what is the meaning of a contract of sale of goods? What is the meaning of a contract of sale of goods? So let's first of all lay a proper foundation, and this then brings us to section 1, subsection 1 of the Sales of Goods Act. Now this brings us to section 1, subsection 1 of the Sale of Goods Act. So section 1, subsection 1 of the Sales of Goods, the Sales of Goods Act defines a contract of sales of goods as a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a money consideration called the price. Now from this particular definition, you can deduce that first of all, the parties involved in a contract of sale of goods is the seller and the buyer. Initially, in law of contract, it was the offeror and the offeree. But however, now it is the buyer and the seller. It is the purchaser and the seller. So these are the terminologies in a contract of sale of goods. Now, from this particular definition, you also know that a contract of sale of goods is where the seller transfers or agrees to transfers. It can be in the present, it can be in the future. I will transfer this property to you tomorrow. I'll transfer it to you tomorrow. So it can be that the seller transfers the property, that's presently, or agrees to transfer the property in goods. Now this property must be property in goods. They must not be land. Here does not connote property. So they are property in goods. They are goods. Land does not fall under this particular category. Now, another factor you need to recognize is that agrees to transfer the property in goods to the buyer for a money consideration called the price. Now, the price in a contract of sale of goods is money. It must not be a goods. It is money. However, it can be partly money and partly goods. For example, I want to buy a book, and then I will say the book is 100 naira, and I will say, take this 15 naira and take my biro, then give me that book. Can you see it? Take this 15 naira and take my biro, then give me that book. Now it is partly money and partly goods. So a contract of sale can be partly money and partly goods. But however, I cannot just say, take this biro, give me that book. Now that's goods. That one does not fall. That one is not a contract of sale. So a contract of sale can just be money. Take this 100 naira, give me the book. Or it can be partly money, partly goods. Take this 15 naira, take this biro, give me that book. So that is it for the definition of a contract of sale. Now, let's now look at terms of a contract of sale. We have defined what's the meaning of sale of goods. Now let's now look at terms of a contract of sale. Now before the enactment of the Sale of Goods Act in 1983, the dominant common law principle was the caveat emptor. So before the enactment of the Sale of Goods Act, the dominant common law principle, it was a common law principle, and you remember that common law principles are usually very harsh. So the principle before the Sale of Goods Act came into being, what was in existence was the common law principle of caveat emptor, which means buyer beware. That was the principle at that time. And this particular principle says that buyers are to take precautions when entering into a contract. There was no protection for the buyer before the Sale of Goods Act came into being to protect the buyer. So the Sale of Goods Act came to protect the buyer. But however, before the Sale of Goods Act came to protect the buyer, what was in existence was the common law principle of caveat emptor, which means buyer beware. So, for instance, when Mr. A, who is a buyer, wants to purchase this barrel from Mr. B, and if this barrel does not suit Mr. A's purpose, the common law principle will come into play. Will say, buyer beware. Why did you not take necessary precautions when you were buying this barrel? There was no remedy for the buyer. It was buyer beware. Beware when you are buying these goods and this goods does not suit your purpose. Beware when entering a contract. There's no remedy for you. Beware. Make sure these goods suit your purpose. Make sure the goods you are buying is merchantable. If they are not merchantable, there is no remedy for you. That was the common law principle. Buyer beware when entering a contract. However, that was how it was before the Sale of Goods Act came. So the Sale of Goods Act came to protect the buyer, to protect the interest of the buyer. That was how the Sale of Goods Act came into being. So we'll now move forward to the proper reason why we are here, which is terms of a contract. So thus, as it is in every contract, the terms of a contract of sale are the obligations of the party in the contract. So terms of a contract of sale, they are the obligations of the parties in the contract. Do this. Do this on so day. Come and supply me this. Those are the terms in a contract of sale. So the terms in a contract of sale, they are the obligations, they are the duties that the parties own to each other. So the duties and the obligations the party own to each other are referred to as terms in the contract of sale. Now, these particular terms can either be express terms or they can be implied terms. When they are express terms, when we say a particular term is express, it means they are expressly stated, they are clear, they are precise. If you don't supply me this bag of cement before on so date, this thing is terminated. Do this, and I will do this. That's it. It is clear. That is when it is said to be an express term. It can be written just like there's a written contract. Mr. A will say, I'm going to do this. Mr. B will say, I'm going to do this thing. It is written down. It is signed. It is seen. In that particular scenario, you see that the terms of the contract of sale, the obligations, the duties of the parties in the contract of sale, they are clearly written down. And also, terms of a contract of sale can also be implied. When we say a term is implied, it means that it is not clearly written down. It is not clear. It is not precise. However, from the circumstances of the contract, you can be able to deduce what the term of the contract is about. So that is it for terms of a contract of sale. Now, you know that terms of a contract of sale are either warranty, they are either condition, or they are either fundamental term. But for this particular purpose, we are going to be focusing on warranty and condition. Warranty and condition. What is a warranty? What is a condition? Now we'll begin. The Sales of Goods Act classified terms in a contract of sale into two categories. The Sale of Goods Act classified terms in a contract of sale into two categories. Now, what are these categories? They are conditions and warranty. So the Sale of Goods Act classified the terms, the obligations, the duties that the party owe to each other into conditions and warranty. Those are the terms in a contract of sale. Now, let's first of all look at the definition of warranty. This then brings us to section 62, subsection 1 of the Sale of Goods Act. So section 62 subsection 1 of the Sales of Goods Act defined a warranty. Now, how does it define a warranty? Section 62 subsection 1 says that defines a warranty as an agreement with reference to goods which are subjects of a contract of sale but collateral to the main purpose of such contract, the breach of which gives rise to a claim for damages but not a right to reject the goods and treat the contract as repudiated, but not a right to reject the goods or treat the contract as repudiated. So for warranty under which was defined in section 62 subsection 1, it defined a warranty. A warranty simply means that these are terms that if when they are breached, the only remedy available is to seek for damages. For example, if Mr. A and Mr. B agrees to do a particular thing, Mr. A says that I will do this, Mr. B says that I will do this. If Mr. A refuses to do one particular thing that falls under a warranty, the only remedy available for Mr. B is to sue for damages. Mr. B cannot repudiate the contract. Mr. B cannot say, this contract is cancelled. So whenever a warranty is breached, the only remedy available is to seek for damages. You cannot cancel the contract. You cannot repudiate the contract. That is what warranty is about. Now, let's now look at condition. Let's then look at condition. For condition, the term condition is not expressly defined. The term condition is not expressly defined in the Sale of Goods Act. The term condition, the word condition, is not expressly defined in the Sale of Goods Act, like the way they define warranty. But however, let's look at section 11, subsection 1, paragraph A of the Sales of Goods Act. Now, this section provides that where a contract of sale is subject to any condition to be fulfilled by the seller, the buyer may waive the condition or may elect to treat the breach of such condition as a breach of a warranty and not as a ground for repudiating the contract. So you can see what this particular section says. Now, before going forward, let's also look at section 11, subsection 1, paragraph B of the Sales of Goods Act. And it defined a warranty as whether a stipulation in a contract of sale is a condition, the breach of which may give rise to a right to treat the contract as repudiated, or a warranty, the breach of which may give rise to claim for damages, but not a right to reject the goods and treat the contract as repudiated, depends on each case on the construction of the contract. Now, looking at section 11, subsection 1, paragraph A of the Sale of Goods Act, it simply means that for condition, when a condition is breached, the remedy available to the victim is that you can either treat the contract as repudiated or you can sue for damages. For warranty, when the term warranty is breached, the only remedy available is to seek for damages. But when the condition is breached, the only remedy that is available is that you can treat the contract as repudiated. You can say, for you breaching this condition, the contract is cancelled, or you can just seek for damages without cancelling the contract. Now, looking at section 11, subsection 1, paragraph A of the Sale of Goods Act, it made mention of something. It says that the buyer may waive the condition or elect to treat the breach of such condition as a breach of a warranty. So section 11, subsection 1, paragraph A is trying to say that you can, when a condition is breached, you can treat the breach of that condition as a breach of a warranty. You can treat the breach of a condition as a breach of a warranty. That is what section 11, subsection 1, paragraph A is saying about. However, you cannot treat the breach of a warranty as the breach of a condition, but you can treat the breach of a condition as a breach of a warranty. And by the time you treat the breach of a condition as a breach of a warranty, what that is called, it is called warranty ex post facto. So when you treat the breach of a condition as a breach of a warranty, it is called warranty ex facto. Now that is it for condition and warranty. So we have said condition are more important thing. They are more vital thing. Why? Warranty, they are less important thing. But that does not mean they are not important. They are important, but they are less important thing. When a warranty is breached, the only remedy available is to seek for damages. But when a condition is breached, you can either seek for damages or cancel the contract or repudiate the contract. And also, you can take the breach of a condition as the breach of a warranty. You can decide to say, they have breached this particular condition, but let me not just treat it as a breach of a condition. Let me treat it as a breach of a warranty. You can decide to do that. And when you do that, what it is called, or it is known as warranty ex post facto. So when you do that, it is called warranty ex post facto. Now, let's now go to the question: is time actually of essence in a contract of sale? Now we are done with what is a condition, what is a warranty. We are now looking at the question: is the stipulation of time actually of essence in a contract of sale? Now that is the question we are going to answer now before rounding up. Now let's first of all look at section 10, subsection 1 of the Sale of Goods Act. Section 10, subsection 1 of the Sale of Goods Act, to answer the question whether time is actually of essence in a contract of sale. Let's look at section 10, subsection 1 of the Sale of Goods Act. Now, look at what it says. Look at what it provides. It provides that unless a different intention appears from the terms of contract, stipulation as to time of payment are not deemed to be of the essence of the contract of sale. So you look at that first part of it. It says stipulations as to time of payment are not deemed to be the essence of the contract of sale. So this particular section is saying unless a different intention appears from the terms of the contract, stipulation of time are not deemed to be essence of a contract of sale. That is what this particular section is trying to say. They are trying to say generally, literally, stipulations of time are not deemed. Stipulations of time are not deemed to be essence. They are not deemed to be that important in a contract of sale. So, for further simplifying this and explain this, let's look at the case of Amadi versus Thompson Appling. Amadi versus Thompson Appling in answering this particular question. Now, in this particular case, the goods were to be delivered at a particular time. The goods were to be delivered at a particular time, but the seller did not comply with the time stipulated. The court, now look at what the seller did not comply with the time stipulated. Now look at what the court did. The court ruled that the time of delivery is of the essence. Thus, the failure to stick to the time provided by the contract was a breach of the contract of sale. So the court in Amadi versus Thomas Appling and Co. Limited said that they clearly stated that the court held that in contract of sale, time is prima facie essence. They are trying to say that in this particular case, this court held that time is essence in a contract of sale. The court held that time is important. Stipulation of time is important in a contract of sale. That is what this court held in this particular case. But however, let's now look at the case of Buhari versus Takuma. Buhari versus Takuma. Okay, Buhari versus Takuma. Now, in Buhari versus Takuma, the Court of Appeal, interpreting Section 10, subsection 1 of the Sale of Goods Act, observed that time of payment is not generally of the essence in a contract of sale, and that the parties can either expressly or impliedly stipulate the contract. So you see what this is almost like a conflicting situation. In Amadi versus Thomas, the court held that time is of essence. In Buhari versus Takuma, the court held that time is not of essence. That's what the court held. So what then is the answer? What then is the answer to this particular situation? Now, in answering this particular question, let's look at the case of Mazin Engineering Limited versus Tower Aluminium in reaching a conclusion as to whether time is actually of essence in a contract of sale. So in reaching a conclusion, let's look at the case of Mazin Engineering Limited versus Tower Aluminium. Let's look at this particular case in reaching a conclusion. Now, this is what the case is about. The respondent was to import a special aluminium sheet to the applicant. So in this particular case of Mazin versus Tower Aluminium, the respondent was to import a special aluminium to the applicant within 4 months. Now, that's the time there. That's the stipulation of time there. They were to import Tower Aluminium to the applicant within 4 months. Unfortunately, this was not possible due to CBN delay in approving the application. It was held that the time of the performance was not of essence. Now, the court in Mazin Engineering Limited versus Tower Aluminium said that the time is not of essence. Now, look at what they went further to say. They said that the time is not of essence because, one, the parties did not expressly stipulate it to be so. So, for time to be of essence in a contract, number one, the parties, they must expressly stipulate it to be so. Now, number two, well, look at the second. The court also held that none of the parties notified the other that unless the performance was completed within a reasonable time, the contract will be regarded as breach. So, for time to be regarded as essential, the parties, Mr. Amos had told Mr. B, see, if you don't supply me these particular tomatoes, if you don't supply me these books within 1 week, you are going to breach the contract. It's going to be regarded as a breach of this contract. It must be clear. It must be expressed. It must be clear. You must notify the other party. If you don't do this, I will regard this thing as a breach of the contract. That is when time can actually be essence. That is when stipulation of time can be regarded as of essence in a contract of sale. Now, the court also held, number 3 now, by the nature of the surrounding circumstances, it is not necessary that the agreed date be strictly adhered to. So time is of essence of the contract. Number one is that it must be expressed, as the court held in Mazin Engineering Limited versus Tower Aluminium. Yes, the court held in Mazin, in Amadi versus Thomas, that time is of essence. The court held in Buhari versus Takuma that time generally is not of essence. But in bringing a conclusion, you see that in Mazin Engineering Limited versus Tower Aluminium, the court held that yes, time is not of essence though, but it's going to be of essence where the parties, number one, they expressly stipulate it. I tell Mr. A, I tell Mr. Japheth, I tell Mr. A that this time is of essence, so it's of essence, it must be adhered to. Now, Number two is that none of the parties notified the other parties that unless the performance was completed within a reasonable time, the contract will be regarded as breach. So for time to be of essence, I, Japhet, I must have told Mr. A that if you don't supply me this product, I will regard it as a breach. So that is the second perspective. Now the third perspective is that from the surrounding circumstances, it must actually show that time was of essence from the surrounding circumstances. For example, Mr. A wants to hold a particular event. Mr. A wants to hold a particular ceremony, and Mr. A tells Mr. B, supply me this special cake. So supply me this special cake. I'm going to use it in the ceremony. Now, Mr. A, from that particular circumstance, you will see that that cake is very important. The stipulation of time that you should supply this cake before the ceremony is very important. If Mr. B then goes on to supply the cake after the ceremony, you see that there's a breach there, because time from the surrounding circumstances, it was of essence. The cake was needed in the ceremony. The cake was needed in the event. So from the surrounding circumstances, for you to say that time was of essence, that time, if from the surrounding circumstances, for you to see that time was of essence, from the surrounding circumstances, it must be sure that it was necessary. It must be sure that this particular product was necessary. So it must be clearly stated. You must have notified the other party that if you don't do this thing, I will regard this as a breach. And from the surrounding circumstances, it must show that actually it was necessary. So that is the conclusion reached. So now let's go back to section 10, subsection 1, and see what it says. Section 10, subsection 1. You see that section 10, subsection 1 says that unless a different intention appears from the terms of the contract, stipulations as to time of payment are not deemed to be of essence of the contract of sale. That is what section 10, subsection 1 says. And in Amadi versus Thomas, they says that time is of essence. In Buhari versus Takuma, the court observed that time of payment is not generally of essence. So in Amadi versus Thomas, the court held that time is of essence. In Buhari versus Takuma, the court held that time is not of essence. But in drawing a conclusion, you see that from the case of Mazin, that there are certain criteria, that there are things that if they happen, time will then become of essence. But generally, time is not of essence. That is why section 10, subsection 1 says that time is not of essence, but unless a different intention. So you must catch that word. Time, stipulations of time are not of essence, but unless there is a different intention, appears from the terms of the contract. So that was what the court held in Masin versus Tower Aluminium. So where a different intention appears from the terms of the contract, where Mr. A, where it is clearly written in the terms of the contract that if you don't supply me these goods within this particular time, I will regard it as a breach, unless a different intention appears from the terms of a contract. Stipulation of time are not of essence of a contract of sale. So that is the conclusion reached in the question as to whether or not time is actually of essence. So you can see that time is generally not of essence, but however, when these criteria that I've given were available, so when these criteria I have given are available, then time becomes of essence. But generally, literally, it is not of essence. So that is the conclusion reached on that particular question. Now, let's then look at the last perspective for this particular video, which is how does a defendant or a plaintiff actually waive his right? Yes, when time becomes of essence, essence and the breach. And when breach, it amounts to damages. When breach, it amounts to breach of contract. When time is of essence and when it's not complied with, it amounts to breach of contract. How then can the plaintiff or the defendant, or how then can the defendant waive his rights? How then can the court say that, the defendant, you have waived your rights? How then can the court say that? This then brings us to the case of Hartley versus Hymans. Hartley versus Hymans. So what happened in this particular case was that the plaintiff and the defendant had a contract. That's for this particular case. And the plaintiff agreed with the defendant that he is going to supply this goods before a particular date. Now that was it. The plaintiff told the defendant, don't worry, these goods you are ordering, I'll supply them before this particular date. These goods that you are ordering, I'll supply them before mid-November. That was what the plaintiff told the defendant. However, he didn't even supply them completely before that time. And the defendant was then telling the plaintiff, time, we agreed on this particular time. We agreed on this particular time. Time is of essence. Supply these goods. Supply these goods to me. Supply these goods to me. So he was pleading with the defendant, was pleading with the plaintiff. Supply these goods to me. We agreed on this particular time now. So that is how it was going, by and by, day by day. The plaintiff will be supplying small, say, supply this thing completely before this particular time. We will be supplying it small. The defendant will say, please, you supply these goods. So he was begging the plaintiff to supply the goods that his customers might cancel their orders and go away. So that is how the defendant was begging the plaintiff. Now, let's move forward. So a particular time came. After that have gone for a particular while, after he had been like that for a particular while, now a particular time came. The defendant told the plaintiff, I'm no longer accepting these goods. We agreed on a particular time that time. It's now you are bringing them. I'm no longer going to accept them this time. That was what the defendant heard. That was what the defendant agrees to do. That was what the defendant did. That was what the defendant purported to do. So the defendant refused to accept the delivery of the goods. Now, the plaintiff instituted an action. You were the one that never brought these goods of time. And it had been going on like that for a while. And now the defendant have refused to accept this particular goods. You have instituted an action. Now, look at what the court held. It was held that the defendant was not entitled to reject the delivery, despite the fact there was time stipulation. But the court held that the defendant was not entitled to reject the delivery under the contract because he had waived his rights to enforce the condition of time. So you see, the defendant that was pleading with the plaintiff, he have waived his rights. The plaintiff, you told the plaintiff, supply me these goods before this particular time, and the plaintiff did not do it. And it was clearly stated that it's going to be regarded as a breach of the contract. Then you took it as a breach of the contract. You instituted an action in court. Then time will be of essence. Time was of essence there. But you waived your right. You slept over your own rights. Vigilante boss no dominati boss jura sovereignty. He slept over his rights. He have waived his right entirely. So the act of the defendant stated that supply me these goods now. Then small one is supplied to you. Supply me this thing. You have been going on like that from day to day. From day to day. The court will say that you are not serious. You have waived your right. So that was what the court held in Hartley versus Hymans. So from this particular video, you have been able to see that what a condition is, what a warranty is, that generally, as you have seen in section 10, subsection 1, time is not of essence in a contract. Stipulation of time is not of essence. But however, when there is a different intention, where a different intention appears from the terms of the contracts, then time becomes of essence. When it is expressly written, when the other party notified the other party that, if you don't do this, I will regard this as a breach, then it then becomes of essence of the contract. And you have also seen that, yes, time can become of essence in that, after doing all that. Time can become of essence after clearly writing it down. Time can become of essence after notify the other party. However, you can also waive your rights. So law is not just a one-way thing. Yes, it can be of essence, but you can waive your rights. The court can say you have waived your rights, especially that's why we brought the case of Hartley versus Hymas, where the court held that you have waived of your rights. You have waived it. You were pleading. You not just it shows you were not serious. From day to day, you were still doing it. You continued the contract. You were still accepting it like that. You were just warning. You were just warning and pleading. So you have waived your rights. So that is it for terms of a contract. So subsequently, we'll be looking at implied terms. We'll be looking at conditions as to purpose, condition as to rights to sell. We are going to be looking at purpose, fitness for purpose, merchantable quality. So thank you so much for watching this particular video. By name, I am Japhet Okaka Ebosetari. Thank you.